Well, hello everyone, and welcome to our topic today, which is the 3 easy steps to get your affairs in order. Excuse me. My name is Lynn St. Louis, and I'm an estate planning and elder law attorney at ELG Estate Planning, where we serve clients in Washington and in North Idaho. We'll be talking about the 3 easy steps to get your affairs in order. And as we go through the discussion today, if you have any questions, don't hold back. Please put them in the chat, and I will do my best to answer them today while we go through this discussion. So feel free to ask any questions with regard to this topic that's on your mind. All right, so why don't we just go ahead and get started then? When we're talking about getting your affairs in order, everybody's heard that term, and interestingly, it seems that I've heard it more after clients have come to me when they have been to a physician, a doctor. The medical field, I think more than the legal field, is often heard to say, get your affairs in order. And we know that that's generally bad news. So not surprisingly, no wonder people shun the idea of getting your affairs in order. We connect that possibly with meaning we're going to die. So getting your affairs in order seems to make it more probable, which I think we'd all agree is inevitable, our physical mortality on this earthly realm, but it makes it more real. So understandably, people maybe recognize getting your affairs in order is a really good idea, but an idea and taking action are not the same. And why face something that seems so difficult? The good news is that if you are joining me today, or if you are listening online later, you are one of those people that are probably think it's a good idea, and you've made huge progress, because clearly, if you're paying attention, if you want to know more information, you aren't putting your head in the sand. So congratulations. That is a great step forward. My goal today is to simplify, to share with you a clear path forward for getting your affairs in order. And that's going to be from the legal perspective. I'm an attorney, an estate planning and elder law attorney. So I will be talking about the legal documents. And often when you hear people say, get your affairs in order, that's what they're talking about, is make sure you have the right legal documents in place so that when you do pass on, you have made things easier for those who you've left behind. That's what the legal documents are intended to accomplish. But really, before we get started with those 3 easy steps, I wanted to spend a little bit more time talking about getting your affairs in order from a non-legal perspective, because there is more to it. Now, if you are embarking on getting your affairs in order, your legal documents in order, you're probably going to be doing these other things, because any estate planning and elder law attorney will likely talk with you about these other non-legal matters. But I don't want to spend all the time talking about legal documents. I want to talk about things from an estate planning and elder law perspective that are very important about getting your affairs in order. So for example, the whole idea about getting your affairs in order is because we all know we're facing an inevitable matter, which we will all pass at some point in time. So part of that is making things easier. Have you taken steps such as make your wishes known when it comes to funeral, cremation, burial? Have you communicated those wishes to anybody, and have you done it in paper? Because asking people to rely upon their recollection at a very difficult time is asking a lot. Have you purchased a prepaid burial plan? Have you put information that you would want in your obituary in writing, or have you even started a draft of your obituary? You can see why people don't want to do this, right? It seems so terribly morbid. But for those people who really want to make sure things are done as they want them to be done, they will take these actions. I read recently that Prince Philip, recall he passed in 2021, just months shy of his 100th birthday, spent 18 years planning his funeral with military precision so that it was just what he wanted. Now think about this. Let's say he was about 100 years old. He spent 18 years. That means he started planning his funeral when he was 82. And frankly, I would suggest that planning at 82 is a little bit late in the planning process. It wouldn't hurt to plan a little bit earlier than that. Other practical thoughts about getting your affairs in order is the documentation. And again, as I said, an estate planning lawyer will talk with you about this. We're going to get to those 3 easy steps in a moment, but getting your important documents organized in one place so they're easy to find. What do I mean by that is we've already talked about funeral, prepaid funeral, but how about bank statements, investment statements, life insurance policies, retirement accounts, titles to vehicles, social media accounts, and passwords to your computer. Just all of those things, if you think about it, when you pass, all of those assets will go somewhere. Well, what are those assets? So do a bit of an inventory with backup documentation so it's easy for whomever has to deal with your estate. And I think I would be remiss if I didn't talk about relationships. When somebody passes, there's a lot of grief. Sometimes people die quickly. Sometimes they linger, and there's a long period of time. I don't know if any of you had the opportunity to attend, but it was a few years back here in Spokane. The author, physician, and writer Atul Gawande, who wrote Being Mortal, he said something that really stuck with me, and I want to share it for what it is worth. With regard to relationships, what he said are these very powerful sentences that make a world of difference. The first thing he said is saying, "I'm sorry, please forgive me." Second was, "I forgive you." The third thing he said was, "I appreciate you and thank you for being in my life." And then the fourth thing he said for healing of relationships was, "I love you." This very brilliant author and physician, there was a large audience there and a lot of people who were interested in the subject of, end of life, etc. And, it was really a profound statement that he made. So I am simply sharing that with you because part of getting your affairs in order is healing relationships, if that's possible. So, all right, you've heard enough of a lawyer talking about relationships. So let me talk about what I really understand and know, which is the legal documents. So what are the 3 easy steps for you to get your legal documents in place so your affairs are in order? Number 1 is decide, make a decision. Number 2 is guide, get guidance. And number 3 is to act and to implement. Now, I told you I was going to try to make this as simple as possible. That sounds easy, doesn't it? Decide, get a guide, and act. So what's the big deal? What's the hurdle? Why is getting your affairs in order seems like it's difficult to do? Well, frankly, it's that first step. It's that number 1 step, which is make a decision. Make a decision to get your affairs in order. Well, why is that? Because you don't have to. There is nothing that compels you to make a decision to get the legal documents you need to get your affairs in order. And frankly, most of us will come back and say, and there's a lot of reasons I don't need to. For many people, they'll say, I'm young, I'm healthy, there's no reason for me to even be focusing in on end of life matters, on legal documents. I know we can all recall back to when we were younger and, absolutely no reason to think about it. But what I can say is, even when there is a lack of urgency, I think we will all recognize that no matter your age, accidents do happen. And as you get older, and as we all age, we probably, many of us experience that there is declining health. There may also be diagnoses, which are either terminal or debilitating. That's when the urgency starts pounding on your door a little bit more, when you say, you know what, it's time. Why I believe that so many people don't get their affairs in order is because they don't have to. And when I say so many people, I think statistically over 50% to 60% of Americans do not have any kind of legal documents in place. So again, as I mentioned, if you're listening to this, you are to be congratulated, because you are at least open-minded to the possibility that it might be a good idea. Making a decision when there is no urgency is proactive planning. Reasons beyond, being young and healthy, et cetera, why people don't want to make a decision to get their affairs in order. I think for a lot of people, and that would be me included, I'm a fact finder. I want to know everything before I make a decision. Well, that's kind of getting the events out of order. If you make a decision, you're making a decision to get your legal documents in place. That is the decision that has to make. You don't have to know everything. You don't have to know, well, I think I'll need a will, or I'll need a trust, and I'll need this, and I'll need that. Unless you are an estate planning and elder law attorney yourself, you can't know all that there is to know about what your legal documents will look like. So that is a later step in the process. The first step is to make the decision. And I would say that, whenever our brains are confronted with all sorts of choices and it seems complex, human nature is just to say, I'm not going to make any decision. I'm not going to do anything. So that's why I want to point out to you that the complexities of the estate planning process, that is something that comes, that we'll talk about, but that is after you've made the decision. Simply make the decision that I want to have an estate plan. I will get my affairs in order. It's all you need to do. You don't need to do anything more than that. The most important step is to affirmatively say to yourself, I will get my affairs in order. Once you've made that decision, everything else will much more easily fall into place. All right. Decision was easy, right? Step number 2, get a guide. What I mean is, you have made a decision that you'll get your affairs in order, that you will have the right legal documents in place, you will have the right estate plan. Well, that is legal expertise is required. When I say get a guide, in this context, when I'm saying getting your affairs in order for your legal documents, what I'm saying is find a good estate planning and elder law attorney. You don't have to know that you need a will, or that you need a trust, or that you need this and that. That is not your job. Your job is to find the right person, the right guide, the right expert, the right lawyer for you. Somebody that you trust, somebody that you have confidence in, somebody that has expertise in what we're talking about. We're talking about an estate plan, and when the estate plan is carried out, which is upon your death. So that person has to be competent. They have to be able to communicate to you in a way that you understand it. They need to take the time to show that they care about you, about your goals, about your family, about your wishes. So competence is important. So is that, compassion, that caring, that that they're your advocate. They have your back. They're the one that wants to make sure that you have an excellent plan, the right plan for yourself. I guess look at it this way. When you go to a doctor for whatever you're going to the doctor for, you want to make sure that you have confidence, that they have experience, that you trust them, and that if they're not the right doctor because, they're your internist and you need surgery, that they're going to refer you to the right doctor, to somebody who understands you and has the expertise that you need for your particular situation. When part of finding the right lawyer is, it's due diligence on your part, is do research. You may have an attorney who helped you with a family law matter or with a motor vehicle accident or personal injury matter. And frankly, I know many of lawyers that specialize in those areas will say, I can do your will. Don't worry about it. It's going to cost you $500. I know you. That's all you need. In my opinion, they are doing a disservice to you. Why is that? Because they don't have the expertise to prepare for you the right estate plan. They don't understand what they don't know. Let's say the attorney who you've worked with before, but it hasn't been in estate planning. They say, oh gosh, all you need is a simple will or a simple trust. That tells me that they don't have a clue. They don't have a clue about estate planning. They don't understand the benefits of a good estate plan. Everybody's situation is different, granted, but everybody wants to have the confidence to know that the plan that they have that's been prepared by the attorney is worth the paper that it's written on, that it accomplishes their goals, it is with their voice, and that if there are ways to protect assets for yourself, for your loved ones, that is part of what your estate planning documents look like. So get recommendations from people whose opinions matter, from people that you can trust. Do your research. Go to, everybody researches on Google. Look at the on the website what it says in terms of, how that attorney has performed, what past clients think about them. As I mentioned, at ELG Estate Planning, we serve clients in Washington and Idaho. Let's say you're listening and you're in Oregon or California or a different state. What I recommend is that you go to the National Academy of Elder Law Attorneys and use that website to find an estate planning and elder law attorney in your state. NAELA.org. That's NAELA.org. NAELA is the preeminent national organization for elder law attorneys. If you are looking for an estate planning and elder law attorney in a different state, you can have some degree of confidence that they will be able to assist you, that attorney you find in the other state. That's not the only place to look. Go to NAELA.org. Do Google research on the attorneys. Look to make sure that the attorney that you're going to be working with really focuses on estate planning and elder law, that they are not a general practitioner. Make sure that they are at a law firm that has sufficient team, the legal team, that they're not a solo practitioner. And there's nothing I can't say anything against solo practitioners, except for the fact that we as attorneys need to have an estate plan or a business succession plan as well. I don't recommend that you work with a law firm where there's only one lawyer. What happens if that one lawyer dies? You want to go to a law firm where there is at least 2, 3, or more lawyers so that there is some safety net for your estate plan if anything happens to the lawyer that you worked with. I just want to mention that experience does matter experience in the area of practice. Again, it's that specialty. It is hard in this day and age for people to be able to know everything. You don't know everything. You know what you know, and what you do if you're an estate planning and elder law attorney is making sure your clients have the right estate plan, making sure you're there to help them or whatever comes up. I can tell you that, clients of ELG estate planning often come to us because we have expertise with long-term care and Medicaid, so we understand how those rules work. Part of then the attraction for clients coming to us is that they know we'll be here for them from here until they pass away, and whatever their journey is. If it involves long-term care, we can assist them, and the documents will have the necessary provisions and authority in them that we don't ever have to refer them off to a different attorney because we don't know elder law. That's one of the things that if it concerns you, long-term care, and you want to make sure that the attorney will be there for you, do look for somebody with elder law expertise. All right, let me move on to step number 3 before we look at the questions in the chat. Number 1, you've made a decision. You're going to get your affairs in order. Number 2, you've done your due diligence and you have found yourself what you believe to be a good estate planning and elder law attorney. Number 3, what's the next step? Implement, act. You found the attorney. Now you need to work with the attorney. And I want to share some information about what does that mean, working with your attorney. You will meet with them. They will ask you lots of questions, detailed questions, personal questions. They'll ask you about your family, about your health, about your finances. Importantly, they'll ask you, what causes you to lose sleep at night? What are your goals? What do you worry about? What do you want to make sure that we cover with you so that you feel really good about the estate plan? Remember, you don't need to know anything about the estate plan. It's not the legal documents that is important. It's what your situation is, what your goals are, what your concerns are. The attorney needs to be able to talk with you about that and explain to you how the estate plan that you will be creating with the attorney, how that accomplishes your goals, alleviates your concerns. I keep coming back to the word understand. An estate plan is not very good if you can't understand it. So do insist with your attorney. If you have to insist, your attorney should know that this is one of their most important tasks, is to make sure you understand what is going to be recommended for your estate plan itself, for those documents. I explained a little bit earlier that when you are starting this process, you've made a decision, you've chosen a lawyer, you don't need to know anything about what the legal documents are going to be. But in this third phase, this third step, when you're working with a lawyer, this is when you need to understand, are they recommending for you that your estate plan be based upon a will platform? By that, I mean that it is not going to be a revocable living trust. There's basically 2 fundamental platforms for your estate plan. Either a will, which will likely go to probate, or a revocable living trust, which intent is to avoid probate. And is one better than the other? I can't answer that because I don't know your particular situation. I can tell you that if your goal is to avoid probate and there is no reason for you to try to protect assets for your surviving spouse against long-term care, even in the state of Washington, then in that case, we would likely agree that the revocable living trust is the right path forward for the client. How did we know that? Well, we got to that by understanding that they wanted to avoid probate. They wanted to make things simple. They have no need for protecting assets against long-term care costs. And that tells me that they likely have long-term care insurance or over $1 million plus in assets, because that is a more appropriate situation to have a revocable living trust in Washington. In Washington, by the way, probates are non-intervention. The fees are not based on the size of the estate. Probate is pretty a simplified process here, unlike other states. If the client's situation is such that they perhaps don't have long-term care insurance, they don't have ample assets well over $1 million, and no matter what their age is, they're concerned that the surviving spouse might become impoverished due to long-term care costs. In that situation, we may well recommend a will-based platform. What that means is, if the situation calls for a probate on the death of the first spouse, we would recommend a probate. And you may say, why are you recommending a probate? That costs more money and it's more work. And I thought I was getting my affairs in order so I would make things easy for my surviving spouse. There is a trade-off, there is a balance. Let me just give you a very simple example. And like I mentioned, I don't want to delve too much into the legal documents, but I want to help you understand that where, let's say we have a couple, they're in their mid-60s, 70, they don't have long-term care insurance, and they have $1 million in total assets. And whether or not they have a diagnosis or not, they're at an age where long-term care is probable, unfortunately. So we would probably include a mandatory supplemental needs trust. And what that means is that on the death of the first spouse, their assets, half the estate, $500,000, goes through their will, through a probate, into an asset protection trust for the surviving spouse. $500,000 is in a trust. Why did we do that? That money in the trust will never count against the surviving spouse should they need long-term care, so that Medicaid doesn't count that money as belonging to them. That's a nest egg, that's a safety net where we know that that surviving spouse will always have available and not subject to long-term care spend down $500,000. This probably is, I probably went into too much detail on that, because my whole point of this talk today is making it simple. And I just bogged down with a bunch of details about revocable living trusts versus wills. The reason primarily I did that was that all of that detail, all of that information, that's what you will be getting when you go to your estate planning and elder law attorney during this consultation, drafting, implementation phase. This is the phase where you are given information and you exchange information with the attorney, and together you will create an estate plan that does just what you want it to do. So the implementation phase is very important. It's probably the longest phase. Well, once you've made a decision to get your affairs in order, this phase of preparing your estate plan, meeting with the lawyer, giving them information, discussing what's the right platform for your estate plan, what do you want to do, that should take between 4 weeks to 8 weeks. Can we do it more quickly if there's urgency? Yes, we can. Does it take longer? Often it takes longer because perhaps the clients need to give a lot of thought because they are having a hard time deciding certain things, like who's the decision makers or where their assets will go. But I just want to give you a rough time frame for what you should expect from your attorney. And of course, my perspective on that is from, what do we at ELG Estate Planning, we typically will want to see, once we've met with the clients and they've had, we start the legal strategy process, 4 to 8 weeks. It can take less, it can take longer. That's just a good range. One of the things that I point out to clients is, once they've met with us and we've talked about the plan, they have a better understanding, they like the plan, it makes sense to them, they might start feeling, a little bit lighter about things. But I have to remind folks that until you actually sign these new estate planning documents, nothing is in place. You don't have the legal documents that you want to protect you, to protect your assets, to protect your loved ones. So that is one of the reasons that we hate to see estate planning process go out month after month. Why is that? Because the client isn't getting what they need. They don't have the documents to protect themselves. Sometimes it's just what the client takes a long time, but that's not ideal. That is really those 3 easy steps. Now, I don't want to forget to tell you that part of that 3rd step, the implementation process for your estate planning, isn't just about legal documents. When we started out our talk today, I talked about other things that are really important to get your affairs in order, organizing your documents, funeral, possibly preparing an obituary, that sort of thing. But from the legal planning perspective, there's more involved with more than just the legal documents, the estate planning documents. Think about your own assets. Your 401k or your IRA may be one of your biggest assets. And generally speaking, those assets are not covered by your legal documents prepared by the lawyer. The lawyer should and will talk with you about making sure your beneficiary designation is set up correctly according to what your plan is. The lawyer may not be able to change your beneficiary designation, but they should talk with you about that. Make sure your bank accounts are set up correctly. You probably don't want joint tenancy with right of survivorship. So there's all these what we call non-probate assets that the lawyer will talk with you about when you're setting up the estate planning legal documents. So keep in mind that you don't need to be the expert. You are not the expert, but who you are is the most important person in this whole process. And that is making sure that you take action, make a decision, find the right lawyer, and then work with them to put the right plan in place for you. Don't let yourself become overwhelmed by thinking about all of these 1,000 details. Frankly, a lot of what we do in estate planning, that's up to the lawyer. What if this happens? What if that happens? We'll work with you. We'll give you guidance. We'll give you recommendations. That's our job as your guide, is to help you with the right estate plan. All right, let me see what questions that we have here. One of the questions is, if all of my financial accounts are in my living trust, what could possibly require that my estate go through probate? Well, that is a great question. And if indeed all of your assets are in the trust, not just your financial account, but your house needs to be in the trust as well. If you've done a good job and you put all assets and they're retitled into the name of your living trust, then on your death, there should not be the need for a probate. And if that was the appropriate planning vehicle, which is a trust for you, then that is great. You have got the right plan. The trust will work as intended. You will avoid probate, and all the assets will go where you want them to go without probate. Do keep in mind that one of the problems when the trustor has died and they've avoided probate is whomever is set up as a successor trustee doesn't realize that they might want to talk to the lawyer who drafted the trust just to get a little guidance about what their job is. They step in once the person has died. How do they know what to do? I don't know what your trust looks like. Sometimes they're skinny, 3-4 pages. Sometimes they're 100 pages. And the trust document itself can be overwhelming. And I'm not saying that's good or it's bad. Sometimes the trust is huge for a reason. Sometimes it's huge and there's no reason. But regardless, the point of it is that whomever is administering a trust after a death, I recommend that they seek legal advice. No, there won't be a probate if everything was done right, but you still need legal advice to figure out, okay, what should you now be doing with this trust? I do want to also mention that there are some assets that typically are not put into a revocable living trust. That would include your IRA or your 401k. Make sure that those have the right beneficiary designations on them. If they don't, sometimes that causes there to be an unnecessary probate. And yes, sometimes there is a hybrid approach with a will-based platform and a trust-based platform. Sometimes we do that when, let's say there's real property that's in California or Arizona or a different jurisdiction, but we want to take all the advantages of having protecting assets for a surviving spouse, and it's in Washington. So we will do primarily the will-based platform, but that doesn't mean you can't also add a revocable living trust to it. So sometimes that is a good way to do it too. Question about stuff, clothes and furniture and all that. And I will also add titles to vehicles. For the gentleman that was asking about the revocable living trust and avoiding probate, likely your car isn't titled in the name of that trust. Usually that just isn't how it's set up. If that's the situation, then whomever is the person who is supposed to receive your car based on what the trust says, typically they just go to the Department of Motor Vehicles with your death certificate, a copy of the trust or the certificate of trust, and the folks there will help you transfer title. That won't require a probate. When it comes to stuff, clothes, personal possessions, furniture, you can always do a list. In Washington, we have a statute that recognizes a personal property list. And on that, you'll say if there's any particular items that you want to make sure go somewhere to someone, for example, just write your list down and then sign it and date it and keep it with your important papers. And that should be honored by whomever is administering your estate, be it your executor, who's also called a personal representative, or your successor trustee if you have a trust. For the things that you haven't clearly designated where they go, usually whomever is receiving your estate then has the option of, divvying it up if goes to a number of people, or, selling it. Oftentimes there's estate sales. There are estate sale companies who would be able to assist with the things that aren't wanted so that people can, if they don't donate them, they can, sell them and get cash for those. It doesn't need probate for that. Stuff typically does not need probate, but usually if all there is stuff, then do a list and then make sure that somebody is in charge. I would say that even if you don't want probate, and let's say you don't have a revocable living trust, because sometimes a revocable living trust is overkill for people with really simple estates. I still would recommend that you have a will to back up what it is you say. Let me give you an example of how maybe we would set up an estate plan, but we don't expect there'll be a probate. So let's say you're a single person and you own a house and you have a bank account and you have stuff. Where do you want it to go? Your will should say that. But as your estate planning and elder law attorney, let's say that you told me, hey, I want everything to go to my nephew. Okay, we will do a transfer on death deed on your house. What that does is that avoids probate. A transfer on death deed, you record it while you're alive. And on your death, the person who is the recipient of that just takes the real estate excise tax affidavit that was filled out when you did the deed, and then goes and records it with the county, and the house now is theirs. Avoid a probate. Bank accounts, you can do a pay on death to that same nephew. And for your will said, I want everything to go to my nephew. So you don't even need to do a personal property list if everything's going to the nephew. Everything goes to that person, and you avoided probate. You had a will as a backup, just in case it was needed, just in case you forgot to do a pay on death or something to direct the assets to that person. So the will backs it up, but we often will set up estate plans to avoid probate and to make things easier for folks. There's a pour over will that covers putting personal property and personal accounts into the trust upon death, have to go through probate. Yes. So this is one of the most frustrating things for folks that have revocable living trusts is, and if you have a revocable living trust and if a lawyer did it for you, they also did for you a will, which is called a pour over will. Why is it called that? Well, that will is intended to capture those assets that aren't in the trust and put them in the trust. Well, because you didn't do that during your lifetime, put those assets in the trust, there needs to be a post-death way to put them in the trust. What is that? That's the pour over will. Pour over wills must go through probate. So there is a probate plus there is the trust administration. So that is an example of a failed plan in that the revocable living trust was intended to avoid probate, but because it was not fully funded, then there needs to be this pour over will filed with the court, probate, and then it gets put in the trust. And you would be surprised, maybe you wouldn't. I can't tell you how many times when we are helping clients administer a state where there is a revocable living trust, it's not funded correctly. Part of that probably was hesitation on the part of a person to seek out the legal services. Like once the lawyer drafted it, they thought they understood it. Maybe they didn't, but they didn't go back to the lawyer to say, I don't really understand this. And then life goes on. And then they buy a new house and they don't put it in the trust, or they open up a new bank account and they don't put it in the trust, or simply didn't understand it from the start and the lawyer didn't help them. I will share with you quite briefly a situation where we helped administer the estate of a gentleman. Another lawyer had prepared the revocable living trust and had given this person no guidance, hadn't even done the deed on the house. So this gentleman had this trust with nothing in it. And he just wanted that one favored nephew to get everything, the house and the bank account. And I've already explained how that could have happened easily through a will and a transfer on death and pay on death. But the lawyer didn't help him with it. And unfortunately, in this situation, when you need a probate and the trust isn't working because it's not funded, in that situation, there were literally 18 nieces and nephews. So we had to give notice to all of them of the probate, which was a lot of work and a lot of unnecessary angst. And this gentleman's plan obviously didn't work to get his affairs in order. And, a lot of that was that where was there a failure? There was a failure at step number 2, not choosing the right guide, and step number 3, not understanding and implementing. This is not that uncommon that people are just hesitant to reach out to lawyers. Why is that? Lawyers charge money and people want to be on the cheap and do it themselves. And not uncommonly when that happens, or they go to a lawyer that charges, $500 or something, they're just not going to get a good plan. And it's going to end up costing a lot more money at the end of the day. Next question. If there is a specific beneficiary for a stock asset upon the death of the primary owner, does the asset basis revert to zero? So this question has to do with the tax code. Currently, it's very favorable. By that I mean, when you inherit an asset, it gets an adjustment in tax basis. So let's say we're talking about a stock. And let's say when you bought the stock, it was worth $10. And on your death, the stock is worth $1 million. Good choice in your investment, by the way. What happens then? You've set the stock up to, it says, a beneficiary. So perhaps on this investment account, you said, I want it to pay on death to this beneficiary. So You bought the stock, it was worth $10. You put a beneficiary or pay on death designation on it. You die. At your death, it's worth $1 million. The basis of that stock is adjusted from $10 to $1 million. So your beneficiary, let's say they want to sell the stock, they want to hold it, they just want their $1 million. They can then sell it and they pay 0 in capital gains tax. So inheriting assets, especially with low basis, is very advantageous. No, the stock basis doesn't go down to 0. It goes up to the fair market value, which is very favorable to whomever receives the stock. That is one reason that we, clients sometimes come to us because they are concerned about losing all their assets to long-term care costs and Medicaid. And you've probably heard people say this, I just want to give my house away or give this away right now. We talk with them about the fact that, that might be a bad idea, but even if it's a good idea, you've lost the ability for the recipient of that property to get an adjustment in basis if you give it away during your lifetime, because that adjustment in basis only occurs upon your death. So, there's a lot to talk about when clients are thinking about giving away assets for Medicaid, but adjustment in basis is one of the things that we always will discuss with them. Does the same scenario apply to annuities or only stocks? I will be very candid with you. When it comes to annuities, I can't answer any of your questions. Annuities are financial contracts. They are very opaque, very difficult to understand. They have all sorts of rules within them. And for that reason, I, as an estate planning and elder law attorney, will always say to you, if you have a question about your annuity, go see your financial advisor. Who sold you that annuity? What are the rules about that annuity? Because I have seen so many different results with annuities when somebody dies. Some are very unfavorable. All the income taxes becomes due. So it simply is something that I am not able to give you any guidance on. I mean, when I see annuities that clients have, what I tell them is go see your financial advisor, because I can't give you advice about what your annuity will do, what will happen with it. Sorry about that. If I could give you an answer, I'd be a financial advisor who could review the annuity and perhaps tell you, but I don't have that. All right. Well, great. Well, I am not seeing any more questions. If you do have questions, feel free to reach out to us. We're ELG Estate Planning. Our phone number is 509-468-0551. Our website is elgwa.com. And we will be sending out an estate planning guide for those who signed up for today's webinar. So very happy that you joined me today, and please just take it and simplify it. Get your affairs in order. Number one, the biggest step is make that decision that you are going to get your affairs in order, and then everything else after that will flow. Thanks again for joining me today. I appreciate it.